Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we are talking about cheating on the bar exam. Cases that should have gone to the Supreme Court of Canada, but didn't. In Ontario, a number of people took the bar exam, and as a result of their exam, the tribunal noticed a number of irregularities, that some of the answers were answered in a way that didn't seem consistent with other answers that were given on the exam. This led to an investigation, and the investigation led to the discovery of an answer key that had been leaked that had the actual answers to the exam that some people had access to. All of those individuals who demonstrated that pattern or who had used that exam key were declared void in their results of passing the bar and had to deal with the implications of that for the Law Society. There was a challenge to the Law Society's decision to essentially blanket everybody who had been involved in this and who had used the key or the study guide without having an individual hearing in respect of each person. And the Law Society was originally found to have been procedurally unfair for not conducting that individual hearing. But on appeal, the Ontario Court of Appeal overturned that decision and found that it wasn't procedurally unfair to not allow those people to be heard about whether or not they innocently used the key without knowledge of the fact that it was in fact a leaked copy of the answers to the exam. And this does raise a very important issue. If we protect procedural fairness in our legal system as one of the most important elements of administrative law, the right to a fair hearing, then certainly any breach of procedural fairness shouldn't just be thrown out like the baby with the bathwater because the outcome of recognizing that breach of procedural fairness may be burdensome for a tribunal or may not ultimately lead to a different result in a different hearing. That's not the point. The point isn't whether or not the Law Society had the right to void the exam results. They probably did, but they still had to do it in a manner that allowed people to be heard, because it's not just the voiding of the exam results and having to retake the exam, it's also the reputational harm that can come from delaying the process because of these allegations, and at a time where the cloud of these allegations would surround anybody who had a delayed outcome of their bar exam and had to rewrite it. And it's unfortunate that the Supreme Court of Canada didn't recognize the role procedural fairness plays, not just in ensuring people have a fair hearing, but also in ensuring that the collateral consequences and the lifestyles of the individuals who are affected by procedurally unfair decisions are not harmed in a way that negatively impacts them in the future when maybe it shouldn't have. Unfortunately, the Supreme Court of Canada probably isn't going to have another opportunity to revisit an issue like this in such an important context, but hopefully they do come back to the question of procedural fairness violations that are then just overlooked in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Please like, subscribe, and share with your friends.